There is a sentence, 3 words, and if you say them the next time a police officer pulls you over, you may hand that officer everything he needs to search your car, seize your property, and turn a 5-minute traffic stop into the worst night of your life, not because you are a criminal, not because you did anything wrong, because 3 words, said in good faith, said with nothing to hide, are legally treated in most jurisdictions across this country as an open door. And once that door is open, you cannot close it. Marcus Webb was a 38-year-old contractor from outside Columbus, Ohio. Legal gun owner, clean record, permit current. He got pulled over on a Tuesday evening in February of 2026 for running a yellow light that the officer believed had already turned red. A yellow light. That was it. Marcus was cooperative. He was calm. He handed over his license and registration without hesitation. And then, because he was honest, because he was the kind of person who does not lie to authority figures, he said 3 words that defense attorneys across this country have spent years begging their clients never to say. He said, "I don't know." The officer had asked Marcus if he was aware of anything illegal in the vehicle. Marcus had a legal firearm, legal storage, legal permit. But there was a jacket in the back seat that a passenger had left weeks earlier, and Marcus genuinely did not know if there was anything in the jacket pocket, so he said what any honest person would say, "I don't know." In the next 12 minutes, Marcus was outside his vehicle in 20-degree weather, watching 4 officers tear apart the interior of his car. The jacket contained nothing illegal. The search found nothing illegal, but his firearm was temporarily seized, his permit was flagged for review, and Marcus spent the next 4 months and over $9,000 in legal fees getting his record completely cleared. He did not lie. He did not resist. He did not have anything to hide. He just did not know the 3 words that defense attorneys consider the most dangerous phrase a driver can say at a traffic stop, and he paid the price for not knowing. My name is Ray. I spent years watching cases like Marcus's work through the legal system from the inside. Good people, legal situations, catastrophic outcomes. All because nobody prepared them for the conversation that happens in those first 30 seconds after the officer reaches your window. That is what this channel exists to fix. If you want to understand your rights before you need them, not after, hit subscribe right now. Because what I am about to walk you through is not theory. It is the difference between driving home and calling a lawyer at midnight. Let us start with why those 3 words are so dangerous. When a law enforcement officer asks you a question during a traffic stop, your answer is not just an answer, it is potential testimony, it is raw material. And in the legal architecture of a traffic stop, certain responses function as what attorneys call a consent trigger. A consent trigger is any statement or action that a reasonable officer could interpret as permission to expand the scope of the stop. "I don't know" is a consent trigger, and most Americans have no idea why. Here is how it works in practice. The officer asks if you have anything illegal in the car. You say, "I don't know." From a legal standpoint, you have just communicated uncertainty about the contents of your own vehicle. The officer now has a documented reason to believe you yourself are not sure whether something illegal is present. That is not probable cause on its own, but it is a factor. And when officers are looking for justification to expand a stop, factors are exactly what they are collecting. But "I don't know" is not the only dangerous phrase. It is one of 3 that defense attorneys consistently identify as the sentences that most reliably blow up an otherwise routine traffic stop. Phrase number 1, "I don't know." You already understand this one. Any expression of uncertainty about the contents of your vehicle gives an officer documented grounds to argue that even you were not confident the car was clean. It seems honest. It is honest. And it is extraordinarily dangerous. Phrase number 2, "You can look if you want." This one should be obvious, but it is not, because people say it all the time in exactly the right tone of voice, with exactly the right cooperative energy, completely believing they are making the situation easier. "You can look if you want." It sounds like confidence. It sounds like someone with nothing to hide. What it actually is in every courtroom in this country is verbal consent to a warrantless search. You do not need to say yes explicitly. You do not need to say, "Go ahead, officer, search away." The phrase "you can look" in any form, in any tone, has been used to validate searches that would otherwise have been thrown out of court. Defense attorneys have to watch video after video of their clients saying those 5 words and then explain to a jury why the resulting search should be suppressed. It almost never works. Phrase number 3, there might be. This is the phrase that almost no one talks about, and it is the one that causes the most damage to otherwise airtight cases. An officer asks if there is anything in the car he should know about. The driver, trying to be helpful, trying to get ahead of something minor, says there might be an old registration in the glove box, or there might be something in the trunk from when my cousin borrowed the car. The word might, in legal terms, might communicates possibility of an unknown. And unknown possibilities in a vehicle give officers documented justification to investigate further. You meant to be transparent. You instead handed the officer a documented reason to search. 3 phrases, each one said by a good, honest, law-abiding person trying to cooperate, each one used against them in ways they never anticipated. Now, here is where most people watching this make the mistake that costs them everything. They hear about dangerous phrases and they assume the solution is silence, complete silence. They think saying nothing at all is the answer. It is not, and here is why. Complete silence during a traffic stop creates its own set of legal and practical problems. An officer who receives no verbal response at all from a driver has broader latitude to interpret the situation as escalating. You're not required to answer questions, but refusing to respond to anything, including basic requests for identification, can result in a detention that lasts far longer than necessary and can itself be documented as suspicious behavior. The goal is not silence. The goal is precision. There is a specific set of responses that protects you legally, keeps the stop moving, and gives law enforcement zero ammunition to expand the encounter. And it has been refined through years of case law, traffic stop litigation, and defense attorney experience into a clean, short script that anyone can learn in 5 minutes. Here is exactly what you say. Step 1. When the officer approaches your window, you have already done the right things. Pulled over immediately, dome light on, hands on the wheel. You hand over your license and registration when asked. You say nothing else beyond polite acknowledgement. Step 2. The moment any officer asks you any question beyond requesting your documents, any question about where you're going, where you came from, whether you have been drinking, whether there is anything in the car, you respond with this exact sentence: Officer, I respectfully decline to answer questions without a lawyer present. That is it. Every word matters. Respectfully, because your tone communicates everything about whether this is an assertion of rights or a confrontation. Decline, not refuse, not won't, not can't. Decline is the legally appropriate word for a voluntary invocation of your rights. Without a lawyer present, and because this phrase immediately triggers constitutional protection that an officer is trained to recognize, it puts the entire encounter into a different legal category. You have not been rude. You have not been threatening. You have not given consent to anything. You have not admitted uncertainty about anything in the vehicle. You have simply communicated that you are a person who knows that constitutional rights exist and that you intend to use them. Step 3. You immediately follow with one question. Officer, am I being detained or am I free to go? This is your legal checkpoint. It forces the officer to make a binary decision on the record. If he says you are free to go, you thank him politely and you leave. You won. The stop is over. If he says you are being detained, the situation has formally changed. He has now made a legal claim that he has reasonable suspicion of criminal activity. At that point, one final sentence. Officer, I am invoking my right to remain silent and I would like to speak with an attorney. And then you stop talking completely. No elaboration, no explanation, no one more thing. The conversation is over and you have given investigators nothing to work with. Now here's the section that catches even people who know their rights completely off guard. And most channels will skip this part because it complicates the clean narrative. The script I just gave you works perfectly in some states. In other states, using that exact script at the wrong moment will get you arrested for something that has nothing to do with whatever brought the officer to your window. 11 states in this country have duty to inform laws. These laws require you to proactively disclose to any law enforcement officer the moment an official encounter begins that you are carrying a firearm, not when asked, proactively. before they say anything beyond identifying themselves. Ohio has it, Michigan has it, Texas has it, Louisiana has it, North Carolina has it, several others. In these states, the moment an officer reaches your window before you hand over your license, before they ask a single question if you are carrying a firearm, you are legally required to say so. In these states, silence is not protected. Silence is a crime. If you are in a duty to inform state and you have a firearm and you go straight into the script I gave you, you are going to have a problem that has nothing to do with the traffic stop. Know your state before you get behind the wheel. Here is how you modify the approach if you are in a duty to inform state. The moment the officer reaches your window, before anything else, you say calmly and clearly, "Officer, I want you to know I am a licensed carrier and I have a firearm in the vehicle." Then you stop. You have done exactly what the law requires and nothing more. You have stated a fact. You have not consented to anything. You have not invited a search. And if the officer then asks any further question, you return immediately to the script. "Officer, I respectfully decline to answer questions without a lawyer present. Am I being detained or am I free to go?" If you are in a state like Florida, Georgia, or Virginia with no duty to inform requirement, you have zero legal obligation to volunteer anything about a firearm unless you are directly asked a question you cannot honestly answer without mentioning it. In those states, the original script is your complete protection. The problem is that millions of Americans cross state lines every single day without knowing which legal framework applies to them in that moment. And that ignorance, not criminal intent, not dangerous behavior, but simple ignorance, and has put innocent, licensed, responsible people in handcuffs. Here is what you do before this video ends. Tonight, not tomorrow, you look up whether your state has a duty to inform law. You write down your state's vehicle storage requirements for firearms if you carry, and you write these exact sentences in your phone right now. "Officer, I respectfully decline to answer questions without a lawyer present. Am I being detained or am I free to go? I am invoking my right to remain silent and I would like to speak with an attorney." You say them out loud. You say them until they are automatic. Because under pressure, with blue lights in your mirror and a flashlight in your face, the words you have rehearsed are the only words you will actually remember. Everything else disappears under adrenaline. Marcus Webb did not know these words. He said 3 words instead, "I don't know," and paid $9,000 for the honesty. He was not a criminal. He was not reckless. He was simply unprepared for a conversation that happens thousands of times every single day on roads across this country. The law already protects you. The Constitution already protects you. The courts have already ruled on your behalf. But those protections only work if you know how to activate them in the moment that matters. And that moment is always 30 seconds long and never comes with a warning. Now you are prepared. Subscribe to this channel, turn on notifications, because when the next ruling drops, when the next state changes its laws around traffic stops and firearms and search authority, you will hear about it here first, in plain language, before you need it. Drop a comment below and tell me what state you are in and whether you knew about duty to inform laws before today. I read every single one, because the conversation in this community is how we stay ahead of what is coming. Stay sharp, stay prepared, and the next time an officer leans into your window, you already know exactly what to say and exactly what never to say.